You cannot defend yourself if you don't know what information the state holds against you, and the way to find this out is by having access to the case file. And in order to effectively challenge an EAW, the requested person has to have access to the case file in the issuing state. And without this information, the ability to challenge the surrender is drastically impaired.
Any type of legal remedy starts with access to the case file, because otherwise we're not lawyers actually pleading in a specific case. We're just spouting generalities, which is not what we're supposed to do. We're supposed to apply the law to a specific case. Without information about the specific case, we can't properly make a defense.
How can you challenge anything if you don't have access to the case file? What kind of a challenge can you raise? I mean, what material do you have to raise any challenge? You cannot know if the person was on the run, if she or he was notified of the hearing. You cannot even know if it's a mistaken identity case. You are completely blind.
When issuing an EAW, many member states don't allow access to the case file prior to surrender. Instead, access is granted only when the requested person is physically located in the issuing state. And this means that the requested person can't challenge the surrender while in the executing state. It also means that the requested person will be detained in the executing state, transferred to the issuing member state, where they again will be detained for weeks or sometimes even for months.
There's no right to the file in any of the countries. The answer has always been no. I have a number of cases currently ongoing, and a number of cases from the past. I have Poland ongoing, Belgium ongoing, Germany ongoing, and none of the cases are cases in which I'm able to receive the file.
And there could be some facts or some issues relating to the national arrest warrant, which could have a massive impact on the proceedings in the executing member state. And without having access to this case file, no one would be none the wiser. So it's absolutely crucial in these proceedings to have access to the case file in the issuing state.
The question is not how would it help? It's how is it possible to say that we have a possible challenge when we don't have the case file? And it's a key issue in France because in most cases you don't have access to the case file before the person is surrendered and presented to a judge. It's too late. It's already taken, in most cases, weeks, sometimes months, and it's too late. Yes, you can challenge, but then it's meaningless. It's a meaningless challenge.
Physical distance should not affect whether or not the defense has access to the case file, and access to the case file should not depend on the requested person being physically located in the issuing state. So reducing reliance on paper files and using digital technology to enable access to a case file would promote equal rights to persons in cross-border proceedings. And digital access to the case file should be made possible in both the issuing and the executing state.
For example, we've had a situation where a lawyer practicing in the issuing state has had to travel over 200 kilometers to a small town prosecutor's office in order to access the case file and take copies of the various documents that he needed. And this took very many days. And as you know, there's a time limit, a strict time limit in the executing state in terms of the arrest warrant proceedings within which they have to be completed in. And even though there's scope to apply for an extension to the deadline, these aren't readily given. And there's always an element of distrust in terms of, well, is the requested person trying to waste time? And in my opinion, the digitalization of criminal proceedings and criminal procedures throughout the Union would definitely aid situations where someone is looking to access the case file either in the issuing state or the executing state, because this would obviously lead to saving very much time, expenses, the environment.
EU must unequivocally clarify that requested persons have the right to access the case file in the issuing state. As of yet, they've not done so.
Things that should be done in the EAW proceedings for the case files, I think twofold. People should get a proper lawyer in the country of the issuing state, and that lawyer should have access to the file. That's it. Those are the most important things.
In order to ensure a better system and more effective access to case files in issuing states, the only way forward would be for the issue to be addressed at union level. The access to a case file varies from member state to member state. And the whole point of European Arrest Warrant proceedings being based on mutual trust is that you can actually trust another member state's criminal justice system. And they have to be more similar in various aspects. And this is an area of law where there has to be similarities and there has to be uniformity throughout the union if there's to be mutual trust.